Mr. Denman, you probably, need to turn on your camera. Great, excellent, wonderful.
I have my skilled
Okay.
assistant who's doing it for me. But okay, thank you. And I guess,
Okay, we all set?
yes, thank you very much.
Denman, you're up.
Okay, may it please the court, my name is Ron Denman. I represent Gloria Price in connection with our appeal, as you know, I'm sure all of you've read everything, in connection with our appeal of the trial court's order denying Ms. Price's motion to intervene and vacate a final judgment. Primarily.
Are you going to reserve 5 minutes, sir?
Yes.
5 minutes for rebuttal? Okay.
Thank you.
So, Mr. Denman, can I ask you a question kind of up front?
Yes.
I just want to kind of get my mind around this a little bit. So your client, Gloria, was married to Adrian and lived in the subject property. Then they got divorced. Then Adrian and his new second wife got a revolving business line of credit for their business.
Yes.
Used the subject property as collateral.
Yes.
Then Adrian divorces his second wife. And then the bank goes into default on their line of credit. The bank then files a foreclosure action and a lis pendens. And then Adrian remarries Gloria, who after a period of time, they resided in a Sarasota house, but ultimately it's alleged they came back and made this their homestead. So Gloria's position is I should be able to intervene in the foreclosure on a loan that I didn't sign on, and that was started before I was married to Adrian. And I got married to Adrian after the lis pendens, and I should still have all these rights. And I don't understand how that squares with our case in Whitburn, because Whitburn stands for the proposition that an after acquired interest, after a lis pendens is filed, is cut off and has no rights. And this seems to me to line up exactly with Whitburn, and I don't know why it shouldn't carry the day here. So help me with that.
Yes, John, I'm glad. Of all the cases I pulled out to really focus on it, one was Whitburn. And I think Whitburn and the line of cases behind Whitburn do support, and I could not find one single case where you have a homestead where someone, an after acquired homestead right, is foreclosed in the same way that a third party purchaser is foreclosed in Whitburn. And Whitburn and the line of cases with Whitburn, as I read them, seem to make it very clear. If you are a purchaser, an actual purchaser of property, after there has been a lis pendens filed, after there's a lien, you as a purchaser are supposed to go look through the record and see what the situation, the title is. You're on notice, you're purchasing subject to, you may be taking a risk, you're taking a gamble, but you are somebody that you should go down and make sure you check out the nature of the title. And that's where Whitburn affects. But Whitburn is—
Well, Whitburn basically cuts off all parties who acquire an interest in the property after the date of the lis pendens. All parties.
I don't believe it goes that far. I believe it's close, but what it says in Whitburn is that it's saying it's well settled that when property is purchased during a pending foreclosure action in which a lis pendens has been filed, the purchaser generally is not entitled to intervene in the pending foreclosure action. And Whitburn then refers us or cites to Bimel for that proposition. And Bimel was a 159 Southern 3rd 345, Bimel versus Bank of America. And Bimel, which essentially the same application, there was a lis pendens, but in Bimel there was factual scenario where Bimel alleged that he was buying the property in a short sale. The Bank of America knew he was buying the property in a short sale, and then reneged at some point and then instituted the foreclosure action. That's why, going back to Whitburn, which is citing to Bimel, it's saying generally that should be the case, but not in all circumstances. Here, we don't have a third-party purchaser. We have Ms. Price who came in in 2010. What we've got here is really—
Counsel, one fact that wasn't touched on earlier was that I think becomes important is after Adrian and Gloria divorced in 1999, she quit claimed her interest in the property to him. So by the time the Wells Fargo loan comes around, she has no interest in that property whatsoever, does she?
Yes, Your Honor, she does, because what happened is he then married Julie. Julie then quit claimed her interest in the property in 2007 back to Adrian, 2 years before the Liz Pendens recorded a quit claim deed of Julie back to Adrian. But then Gloria moved into the property in 2010 and lived there for years, did work.
What property right does that give her by simply moving into the house?
By moving
The quit claim from the second wife was not to her, it was to Adrian.
She remarried Adrian, Your Honor. Once she remarried Adrian and they're both living there.
Saying that's what gave her a right to the property?
Yes, once they're living there as husband and wife for several years, and where we say is
On the
But
second
they
marriage.
they never even recorded evidence of their marriage in and among the Hillsborough County public records, and no one could have discovered that.
Because they got married where, in the Cayman Islands or somewhere, I seem to remember.
That's true, but obviously they could have discovered it because they did discover it before the writ of possession won. There was the recording of the quit claim from Julie back to Adrian, which gave notice, then bring your lawsuit, your foreclosure against unnamed spouse and against tenants in possession. The Liz Pendens and the complaint did not name any unnamed spouse.
And she agreed to the writ of possession, and she never appealed the writ of possession. Is that right?
That's what's in the brief. She did not appeal. There is no evidence. That's why at the evidentiary hearing, we had Mr. Porter there to respond, had there been an evidentiary hearing, that she never agreed to the writ of possession. That is absolutely.
Well, did she appeal from it?
She did not appeal from the writ of possession, Your Honor. That is correct. But she still was denied her right to intervene, and she has a due process right. If she has a homestead.
So what does the Liz Pendens mean then? I mean, why do we jump through these hoops and file these darn things if they're not cutting off people's rights? So a foreclosing entity knows at some point there's a certain pool of people that have an interest in this property, either as owners or as lien holders. I mean, why file the darn thing?
Well, it's just file the darn thing and then sue everybody. Don't just sue half the people. I mean, if they had sued her, would she have beat Wells Fargo's lien? I'm not suggesting she would have, but she still could have.
Mr. Denman, can I interrupt? And
I'm sorry, I'm screaming.
No, you're not. You're not. You're being very passionate, I think, Mr. Denman, on behalf of your client. But I guess my question is as follows. At the time that suit was filed, at the time that Wells Fargo filed the complaint and Liz Pendens, Adrian was not married to Gloria. Is that correct?
That is correct.
All right. And Gloria was not even named either as a signatory to either the note or mortgage at the time. Is that correct, Mr. Denman?
Yes, ma'am, that is correct.
Okay. So help me out. How can she, if at the time of the complaint, at the time of the Liz Pendens, and at the time that he was not even married to her, she's now claiming that she has homestead in the property. Am I missing something, Mr. Denman?
Yes, because I'm not trying to suggest the three exceptions to the homestead. We know what they are: purchase money, the security interest, and essentially mechanics lien. I'm not suggesting that had they put her on notice, she would have been able to be superior to Wells Fargo. But with her husband, with the protection for the family unit, they had been living there. She spent money. They raised their kids there for years. She could have come in and redeemed the property before the sale. She could have made sure that they don't get kicked out of it. There was, the loan was $111,000. They sold it for $410,000 to the bank. She could have at least come together as the family and made sure they didn't get kicked out of the house. That's what the homestead right is, that she developed by living there. And there's a bunch of other facts that really not necessary to get into with the Chase mortgage that sort of go into Bimel and the reasonable expectation why it's generally the Liz Pendens will apply. But she still, every year, she still had a right, a due process right. The homestead right attaches when she moves in and intends to make it her home. That's when it attaches, according to all the case law I've cited. She did move in. She changed everything. She abandoned the property in Sarasota. This is what we proffered at the evidentiary hearing. She absolutely had been completely gone from the Sarasota property long before the amended complaint in 2012. She lived there. She made it her home. At minimum, what I'm saying here is not that we would have beat Wells Fargo, not that she could have somehow kicked their mortgage out of place, but as a homestead interest and the protection our state gives to the homestead rights to keep the family unit, they could have redeemed that $111,000 had she had the notice, had she been able to come in. That's what the evidentiary hearing, had I been able to get it, would have provided the information. I submit that Mr. Adrian Price, he had similar beliefs like Bimel dealing with Chase, but had she been able to come in before a certificate of sale was issued, she would have been able to exercise the redemption, give him the money to exercise the redemption. They would not have lost the home. As a homestead, as an equitable interest in the homestead, at minimum, that's where I'm going with this. At minimum, she had a right to to get notice and an opportunity to be heard. That's what our law is saying. I'm really not trying to come in here and be disingenuous and say somehow we would have kicked out, taken priority over Wells Fargo. But she still had a right as the spouse living there for years to get notice, opportunity to be heard. Even before Wells Fargo got its sold the certificate of sale, they did a motion did a motion to inspect the property. That he had a right to go out there. They would have been on notice that she was living there. If she's living there, they just refused to go out there. They know she is a resident of the property, therefore give her notice, an opportunity to be heard. That's what she was deprived. And that's the main crux of everything here. Did she have a right? And the cases talk about, especially the Azem case, and I'll make it quick because I mean, obviously you've gone through the material and you've asked me some very pointed questions. So I don't want to go on too long. I'm happy to answer questions, but I think the Azem case was 153 Southern 3rd, 341 is just so significant in its holding, where you have a husband and a wife. You have the wife getting a fraudulent mortgage, and you have the husband coming in pro se, essentially filing a motion to prevent the certificate of sale, and really citing to Article 10, Section 4 of the Florida Constitution, protects a homestead from a forced sale, and Florida courts have emphasized that homestead exception is to be liberally construed in the interest of protecting the family against the claims of creditors. The fact that appellant does not hold record title of the property is immaterial, because record title is not a prerequisite to a finding that a property is homestead. Homestead status may derive from here the husband's beneficial interest as head of the family in the marital home titled in his wife's name. Failure, and then finally failure of a spouse to join in the alienation of homestead property. Well, this goes to, I guess the difference with Azem that is different is the wife improperly alienated the husband's interest in.
Well, none of those cases, not a single one that you cited, has our facts. On almost all of those cases, the parties are married at the time the mortgage is entered into, but one or the other didn't join. This is a completely different scenario. She didn't join the mortgage. She wasn't married at the time. She had quit claimed her interest at the time. At the time of the default, she wasn't married. She still wasn't involved. At the time the foreclosure was filed, she still wasn't married. She shows up after the lis pendens. And frankly, if we were to rule your way, there'd be a whole plethora of people getting married just before these foreclosures are sold on the courthouse steps. I mean, people would be saying, hey, there'd be all kinds of marriages. I mean, the marriage business would take an uptick.
Well, Your Honor, one thing, at the time of the amended complaint, the default judgment on the amended complaint, they absolutely were married, if that matters. Your Honor, there would be perhaps an uptick, but we're talking about a homestead right. She cannot come in and defeat the lien if it was superior. I'm not saying that, but one of the most fundamental aspects of the statute of a homestead is that you have a right to redeem so you don't lose the property. Now, Mr. Price had a different understanding based upon his litigation with Chase that he wasn't going to lose the property. She still had an independent homestead interest that if it came down to losing the property or paying $111,000, she would have had that ability to do that. That's what.
Just so you know, sir, you're into your rebuttal time, but it's
I'm
your
sorry.
time. You can use it any way you want.
I'm finished, Your Honor. Thank you for this.
Okay. All right. You'll have 5 when you come back. All right. Ms. Rotman, your
Good
turn.
morning, Your Honor. May it please the court, Emily Rotman on behalf of Wells Fargo Bank N.A. As the court has aptly noted, this appeal boils down to borrower's now wife's efforts to vacate a nearly decade-old foreclosure.
But Ms.
judgment.
Rotman, what about it? Is there anything special about this homestead status that Gloria is claiming after the list pendants? Does that somehow make Whitburn not applicable? I mean, homestead's a big thing. Constitutional homestead, that's a big thing. And you know, so why doesn't that sort of fall into a special category that Whitburn doesn't apply to and the list pendants doesn't cut off?
Sure. Well, the list pendant statute talks about interest generally. It doesn't talk about purchase interest. It doesn't talk about a creditor's interest. It doesn't talk about homestead interest. It speaks to interest generally. So it's our position that Whitburn and its related cases are sufficiently broad because they look at that list pendant statute and that language that just says interest. It doesn't specify what kind of interest. It just speaks to interest. And as this court noted, if you were to read that list pendant statute narrowly, you would run the risk of people getting married days, weeks before you went to foreclosure judgment. And the bank would then, I suppose, have to check and hope they located any marriage that wasn't, as the court noted, in the public records.
Now, does it matter in this case? Yeah, in this case, they got married in the Virgin Islands, if I remember correctly. And
Correct.
so I guess documentation wasn't filed. Does that matter?
I think it does. I mean, I don't know that it should matter, but I think it certainly bolsters our opinion. I think the list pendant is dispositive of the issue and cuts
Is it
it
a
off.
valid
regardless.
marriage?
I don't know that that's for me to decide today, and I don't know that the court had to decide.
Well,
that
if it's
below.
not a valid marriage, there's certainly no homestead issue.
that
And if she was
wasn't
married in
briefed.
the
I don't
Virgin-
want to address the validity or non-validity.
I don't know if she was
of the
married in the
marriage.
American Virgin Islands or the British Virgin Islands. That could make a difference.
But regardless, I think the list pendants is dispositive here, but even if it weren't, I think it is important. And I think the court noted below that if Wells Fargo had gone to run a new title search, she wouldn't have shown up. As the court noted, she previously quitclaimed her interest in the property not once, but twice. And the second time actually acknowledged that she had no homestead interest in the property. And that was what was in the public records, not any marriage of or any record of any marriage that may or may not have taken place in some islands. And just to, kind of to go back, I think the court has noted that to follow Ms. Price's argument here, you would have to kind of truly eviscerate the list pendant statute and do so. For those reasons, the motion to intervene and motion to vacate were properly denied, and I'd like to take those kind of in turn. First, there's her request to intervene, and that's important here because non-parties to a case typically need to intervene absent some showing of fraud before they can move to vacate a judgment. So that was kind of her first step. And she falls down, quite frankly, there. First, as a general rule, purchasers pendent lite are not permitted to intervene. And that's the Whitburn case the court has already talked with opposing counsel about. But we're not entirely even there because we're now under the different standard because this is post-judgment, where the general rule is you simply don't allow intervention. Regardless of whether Homestead gave her a little more interest than a purchaser pendent lite, it doesn't matter because we're now post-judgment. And the majority of the case law that Ms. Priest cites either talks about that pre-judgment rule, which we're not in at this point, or it deals with folks who had an interest before the foreclosure began, before that list pendants was filed. I think it's also important here that Ms. Priest previously sought to intervene twice. Counsel acknowledged in the hearing below that twice in 2014 Ms. Priest sought to intervene. That's not something she appealed at that time. I think the Carlisle case from the Third District Court of Appeals in 2017 is dispositive on this issue. It says when leave to intervene is denied and that decision is not timely appealed, which it was not here, the non-party lacks standing to later file a 1.540B motion. And I think that's really the end of the case on some level. But regardless of whether intervention was properly denied or not, the 1.54 motion also should be unsuccessful here. She doesn't, any interest she may have acquired was after that lis pendens, and the lis pendens statute, as I noted, does talk about interest. So this is a question of timing, not a question of the character of whatever interest it was she may or may not have obtained. She's not an indispensable party. The case law she cited there is not relevant here. Talks about record title holders, which, as this court has noted, she was not. As such, there's simply no need to serve her with process in this case, and therefore she was not served with process. I think it's also important the court keyed in on this, that she may have waived any of these arguments by agreeing to the writ of possession. And I would point to page 640 of the record, where in some briefing, counsel actually noted that both of the Prices did agree to that writ of possession. So I think that issue is in the record and decided on that point. Finally, I want to touch briefly, counsel mentioned that there was no evidentiary hearing below. And while it's certainly true that in many, and in fact, probably most cases, there should be an evidentiary hearing on a 1.54 motion, that's only important where there's a colorable entitlement on the face of the motion and the affidavits that accompany it here. And I think Cottrell versus Taylor, Bean, and Whitaker, which this court decided in 2016, is important on this issue. It says where the allegations of the Rule 1.54 motion do not give rise to a right for relief, an evidentiary hearing on those allegations is not required. And that's really what the court did here below. Listen to argument from counsel. It heard that the timeline, which is what's important here, was agreed to. You've heard counsel acknowledge today they were not married at the time of the mortgage, not married at the time of default, not married at the time this foreclosure was filed. And as such, because that timeline was so clear, the court found that on the face of everything, there was no need to hold that evidentiary hearing. The final point I'll address is the right of redemption. Contrary to any argument she may have, any such right is cut off at the time of certificate of sale or certificate of title under Florida statute 45.0315. And the Fifth District Court of Appeals in Burns previously addressed that is so even if an individual is not a party to the foreclosure proceedings, as Ms. Price was not here. So any redemption right is moot at this point. Unless the court has any further questions for me, for these reasons and for those stated in the brief, we ask that the order below be affirmed.
Thank you very much. Mr. Denman, you have the last word and 5 minutes to make that last word.
Thank you, Your Honor, and I'll be very quick. Just to make sure it's clear, they were married at the time of the default on the amended complaint. I think that's important. We did not agree that and there was no evidence of it, that my client agreed to a writ of possession. Just going back to the case of the lis pendens, even under the Whitburn case, the lis pendens is to operate to protect its proponent by preventing intervening liens that could impair or extinguish claimed property rights. No one's saying that, as I mentioned, she could have impaired, but she had an interest under the Hutchinson case. She had a right, a colorable right to a homestead interest in the property. Therefore, due process of law required that an interested person have a fair notice and reasonable opportunity to be heard before a judgment or decree was entered. What would have been different is that the property could have been redeemed. To come in now and say that we deprived her of due process rights, so therefore the argument of a right for depression is, right of redemption is cut off, is really somewhat disingenuous. The bottom line is our homestead protection is one of the greatest in the country here. That's under our Constitution. She, as we proffered in the hearing, she did, according to all the law, have a homestead interest. There's not one case I could find, search up and down, where a lis pendens cut off someone's homestead interest from being able to get due process notice and an opportunity to be heard before the final judgment. So thank you all for your attention and thank you for the questions.
You both did a great job. We appreciate it very much. Have a good
Thank
day.
you.
Thank you very much.
Our next case is Geico versus Glasgow.